When the parliamentary leadership submitted to President Uhuru Kenyatta the Election Laws Amendment Bill of 2017 19 days ago, all eyes were on the head of state, the international community and religious leaders, urging him not to assent to the bill, whose passage in the two chambers of parliament was acrimonious, with NASA members of parliament boycotting house sittings when the proposed changes to the election laws were debated.
But when the bill was brought to me for signature as president, I was also compelled by my own conscience to go back to the origins of law. If an act of parliament is a direct expression of the will of the people, are the people happy with the law?
But the bill by default has become law at the lapse of 14 days that Kenyatta had to determine the fate of the proposed amendments to the election laws. He had an option of assenting to the bill or returning it to Parliament, with a memorandum outlining reasons for declining to sign it into law. But he opted to remain mum and awaited the 14-day timeline to lapse, and the bill became law by default last Saturday.
Others argued that to change the electoral law ahead of the 26th election was to privilege myself over the other competitors. And because the law must be founded on reasoned national consensus, I listened to these voices and I did not sign that new bill into law.
The law was gazetted today on the eve of the 7-day deadline for publication, as outlined in Article 116, Sub-Article 1 of the Constitution. The law becomes operational in a fortnight, according to Article 116, Sub-Article 2 of the Constitution. The new legislation requires the Supreme Court to consider a presidential election in totality before making a decision on its validity if a petition is filed. This means a petitioner must demonstrate that errors or discrepancies in the election have a direct effect on the poll outcome. The law also reduces the IEBC quorum from 5 commissioners to at least 3 and gives results physically delivered prominence over those electronically transmitted should there be inconsistencies.
The rule of good law does not discriminate. It gives us the right to act and the right not to act, the right to vote, and equally, the right not to vote.
But hours into the new law's gazettement, 2 civil society organizations moved to court, challenging its implementation. Katiba Institute and the African Center for Open Governance, AFRICOG, through lawyer Waikwa Wanyoike, want the court to declare the law invalid and unconstitutional in its entirety. They claim the laws were passed by Parliament hurriedly and maliciously. Katiba Institute and AFRICOG are among civil society organizations expected to file a petition at the Supreme Court, challenging the outcome of last month's repeat presidential poll. Francis Gashuri, Citizen Live at 9.